Thank you very much. So I'm going to start with the first round of questions. And I just want to say how glad I am to have all four of you here today, that we have 4 general counsels for the Department of Defense, the Army, the Navy, and the Air Force. The 4 of you are the top lawyers at the Pentagon, and it is your job to oversee compliance with our ethics laws. I am deeply grateful for your work. I obviously believe it is very important, and I appreciate your being here to explain to us and to say publicly how these laws work. So what I want to do is I just want to kind of run through some examples and make sure I understand exactly how some of these pieces go. One of the key guardrails in our conflict of interest laws says that if an official is, quote, personally and substantially involved in a Pentagon program and then leaves to go to work for a defense contractor, they are permanently barred from coming back and lobbying the Pentagon on behalf of the company on issues related to the program that they used to work on. Boy, do I get what we were trying to accomplish with that, and I think that's terrific. I just want to look at maybe some loopholes in that. So, Ms. Crass, let's say that a Pentagon official helped write the contracts between the Pentagon and Lockheed Martin for a multi-billion-dollar weapons program. Under current law, as written, would that person be prohibited from leaving the Pentagon and joining Lockheed Martin's board?
Thank you, Senator. And I absolutely share your commitment to maintaining the public's trust and to avoiding any appearance of conflicts. Applying these laws is very context dependent and fact specific, but in general, the procurement integrity laws would prevent an acquisition official from accepting any compensation from a defense contractor for...
So anybody who helped write those contracts. So when Jim Mattis was told that he couldn't represent Theranos on a particular matter, but that he was free to go join their board of directors, that was okay.
So I can't opine on that particular situation.
Well, that's what happened.
But generally speaking, if somebody has left, if they have worked on a particular matter involving specific parties, they may not come back to the government on that particular matter.
But they can join the board of directors of the company that's talking to the government.
So as I mentioned, if they are a former acquisition official, then they would not be able to if they were involved in a contract of $10 million or more.
So you don't think Jim Mattis was involved in any contracts worth $10 million or more? This is just public record. I'm just going by what's public here. It looks like to me there is a big loophole for people who go off and just join the board of directors, which, by the way, is a pretty good job, because it turns out, according to their SEC filings, Lockheed paid its board members more than $300,000 a year. So it's a nice gig. So let me ask you another one. Ms. Crass, under our current ethics laws, would this person be allowed to be a consultant paid by Lockheed Martin to advise Lockheed Martin on how to respond to DOD in order to win future contracts from the Pentagon, so long as they personally didn't come in and lobby? Would that be okay?
So they would not be able to, and again, these are all context dependent.
I understand that, and we'll keep that as a running objection.
Okay. But they would not be allowed to use any proprietary information or any other non-public information.
The point is, the question I'm asking is, can they come in, can they consult and tell you how to do it, as long as they're not the ones who show up in the office?
I think under existing laws, they would have to be careful not to use any proprietary or other non-public information.
But otherwise they get to do that. Let me try one more. Under current ethics laws, could this former Pentagon official's consulting work include helping Lockheed Martin develop a public campaign to win new contracts, including targeting former colleagues, again, so long as they don't do any direct lobbying themselves? Would that be okay?
I think that again, the same laws would apply in terms of not being able to use any proprietary or non-public.
I understand that, but the question I'm asking is, can they come and do this under the current rules? You sound like you're reluctant to say yes, but we know it's happening. It's in the public domain. We've already read these stories. People have testified to it directly.
What I can say is that on the DOD side of the equation, we are committed and our officials are committed to upholding the ethics laws and making sure that they
I understand that you're
unduly
committed to upholding them as written, and I'm not trying to give you a hard time here. I'm just trying to see how effective what is written and what you've got to deal with. I get it that you can't enforce laws that don't exist. What I'm trying to do is figure out from the point of view of the Congress whether or not we need to do a little more with those laws so that there aren't as many holes in them. So let me try another one. Mr. Bashar, let's say that Raytheon hires this colonel 1 week after, oh, I've got one, I'm sorry, set it up wrong. Let's say we have an Army colonel who worked at the Defense Security Cooperation Agency, DSCA, which is responsible for overseeing arms sales to foreign countries. So, Mr. Bashar, let's say that Raytheon hires this colonel 1 week after he retires from the military to help them lobby to speed up approval of a Patriot weapons system that will make them a lot of money. And he reaches out to the Air Force, you get where I'm going with this, for a meeting. Is there any reason an Air Force official can't take that meeting?
Senator Warren, Ranking Member Scott, Senator Kaine, I appreciate the opportunity to be here today, and I'm joined this morning by a number of my colleagues from the Ethics Department within the Air Force, and they provide a vital service to the department, and they do it well. To your specific example, provided that the hypothetical colonel is not subject to a lifetime bar or
that's
a
my
2-year...
question. Is he subject to a lifetime bar if he goes over and lobbies the Army instead of DSCA?
Yeah, and assuming that he's not subject to such a bar or a supervisory bar, then he could have such a meeting, because at that 06 level, he's not subject to the cooling off period.
I'm just trying to get how skinny this thing is. And the last question I want to ask is about the one we were talking earlier about going to work for Saudi Arabia and other foreign countries. So I just have a question around that. And maybe, Ms. Crass, you're the one to ask this. When this more than 95% approval rating that's coming through on the DOD approval of our high-ranking military officials going to work for foreign governments, I just want to ask, is there any requirement under current law for the Pentagon to consider whether this work would enhance the national security of the United States of America?
Yes, Senator Warren. So the way that the system, as you, I'm sure you well know, is set up is that the Emoluments Clause precludes accepting compensation from working for a foreign government, and Congress has consented, unless Congress consents, and Congress has consented to that in certain circumstances when the Secretary of a military department has approved and the Secretary of State has approved. I
understand that, and I appreciate it, and I'm way over time, and my colleagues are being very generous with me. The question I'm trying to ask you is there anything that requires the Pentagon to look at whether or not it is in our national interest to permit this general or admiral to go work for a foreign country?
So what I'd like to do is to defer to any one of my colleagues, perhaps.
Yes. Mr. Coffey?
Well, because in fairness to Ms. Crass, Congress delegated the approval authority to the MilDep secretaries and really don't include the Secretary of Defense, although we're always happy to get
Fair enough. Fair enough.
Happy to get guidance from our friends on the third deck.
Glad to have the help.
Which we get a lot. The answer is yes. In the Department of the Navy, the standard is, would approving the employment be inimical to the national security interests of the United States? That's sort of the headline.
Okay, that's inimical, though.
Yes, it is. There are 4 substandards, which I'm happy to share with you at the department. But remember, we're talking about whether someone who served their country and is retired, what restrictions, if any, we're going to put on their employment.
Right.
Obviously, we have the Emoluments Clause, and then we have permission from Congress if 2 federal entities, 2 executive branch entities, approve it.
Right.
The Department of the Navy and the Secretary of State. So the questions that are posed, and there's a very rigorous process, which I'm happy to share with you either today during questions or questions for the record afterwards. But among the questions that in the Navy and the Marine Corps are the following: whether the foreign civil employment will adversely affect.
Okay, I get adversely. You heard my question. You can just answer my one question. Do you, as part of your routine questions, ask, does having this admiral or general go work for a company that works for the People's Republic of China or for Saudi Arabia or for the UAE enhance the national security for the United States of America? Is that one of your questions?
On the files that I have reviewed, I have seen that discussion. For example.
Okay, is that one of the questions you are internally required to ask? This shouldn't be that hard.
It's certainly in all of the various files that I have looked at, it is there. Ultimately, the State Department decides whether it's in the interest of the United States and whether it should be approved. But
Well,
it's
that's what I'm
something.
trying to get at. If anybody's actually looking at that, you're telling me it is a question that you answer each time, and the 95+% that you approved, you believed that it would enhance the national interests of the United States of America for that general or that admiral to go work for the UAE or Saudi Arabia. Is that right?
To be
That's what you're
precise,
telling me?
Madam Chair, what I'm saying is that the standard is a negative standard. It's the opposite of what I said before. However, in the files that I've reviewed.
That was the question I asked.
That is where, and I will just say that Undersecretary Cisneros has directed each of the MILDEP secretaries to take 90 days to look at this and come up with whether we can do this a better way. And I can tell you we're all jumping in on that. I've had a chance to look at how Army does it, how Air Force does it. We think we can improve it. We're looking at that.
Please understand, I'm not your enemy here, and I'm not the enemy of the people who are sitting behind you. I am grateful for the work you do. I just want you to have the tools so that you're getting backed up by the United States Congress, and that you're not in a position where the standard is so flimsy or where there are so many exceptions that there are other ways to accomplish what it is that we clearly didn't want to have happen. And I'm just really concerned. I see a 95%+ approval rating to go work for countries like Saudi Arabia and the UAE and countries that have terrible human rights abuses. And I think, how could that be good for the United States of America? And that, to me, has to be our standard. So I just want to get us in the right place. Senator Scott.